A very peculiar thing happened in the South African legal system recently when a High Court judge, Koos Malan, instructed two legal teams who were appearing before him to prepare arguments and papers to explain to him why they were white and not black. The matter before him was between a civil engineering firm and the commissioner of the Broad-Based Black Economic Empowerment Commission. Acting on behalf of the BEE Commission, Senior Advocate Johan Brandt responded in a memorandum saying that the matter that was raised by the judge had nothing to do with the merits of the case, nor would it have any impact on the outcome of the case, and therefore that it is improper for a judge to raise such an issue. In a follow-up, Advocate Brandt argued that it was improper for a judge to insert matters into a case that had nothing to do with the actual matter before him. Solidarity has written to the Judicial Service Commission asking for this judge to be investigated and removed for improper conduct. Now, South Africa's great white woke, the so-called constitutional expert, Professor Pierre de Vos, initially remarked that it was indeed strange for a judge to do such a thing, but then later turned his targets on the evil white people, saying that appointing white advocates was an incestuous practice. Now, I want to make some remarks about this issue. For this, I'm going to rely heavily on an article that was recently published by Professor Koos Malan, for which I'll add the link in the description below. The first is that what effectively happened in this case was that the judge has decided to become an applicant in a matter with regard to which he was supposed to be a judge. It's the equivalent of a referee in a rugby match picking up the ball to go and score a try while handing out red cards as he moves along. But the judge did decide to insert this matter into the case and then instructed the legal teams to prepare arguments. The question then is, who has to pay for the work that is being done in this matter? Should the clients pay for their lawyers who are preparing arguments on a matter that had nothing to do with the case, but that the judge demanded to become a part of the case? Or should the judge pay for the legal fees in this regard? But there's an underlying, much more important issue that should be raised here, which deals with the very core of constitutionalism. The very essence and core of constitutionalism is about preventing abuse of power, which is why things like the separation of powers and having a mixed constitution is so important, precisely to prevent absolutism from taking over. What happened in this case was a very clear example of absolutism, of a judge deciding to become involved in issues that was outside the realm of his responsibilities and powers, but doing so nonetheless, obviously to great applause of ideologically inclined people who are part of our society. So the strange thing here is that while a move like this by this particular judge is bad for the law in South Africa, it's bad for the judiciary, and it goes against the grain of the very principles of constitutionalism, it is good for the career of this particular judge, precisely due to the fact that the political elites in this country have been consumed by race-baiting ideology. And so where does this bring us? It shows to us in the first place that there are some serious problems in the South African legal system. This does not mean that we cannot use the legal system. Organizations like AfriForum and Solidarity have won countless cases in the courts in South Africa. But it has, however, showed to us that the South African political dispensation has some very serious problems, and that the problems in this country are much deeper rooted than simply saying that the wrong political party is in power. The issue here is that those in power, whether they are the government, politicians, or members of the judiciary, have too much power and that they are not being held in check. Which means that the checks and balances that were so much celebrated with the adoption of the South African Constitution in the 1990s do not work. Which means that if we want a more secure, a more prosperous, and a more stable future in this country, we need to recognize that the problems go deeper than simply the government in the narrow sense of the word. If we really want to move forward in this country, we need to recognize that there has to be some constitutional changes which imply that those in power should have less power.